Further hearing the appeal Serafin against Malkiewicz and others.
Before you resume this page, can I just mention one matter that that occurred to Lady Arden, and which I think it would be helpful for us to receive any assistance that you're able to give us. Not at the moment, because I think the point isn't one you've prepared, but perhaps in written submissions. It has occurred to us that sometimes in a situation where a judge is accused of misconduct during a hearing, the judge himself is asked by the appellate court for his observations on the allegations being made against him. As we understand it, that wasn't done in this case. If there are relevant authorities on the practice of the particularly the Court of Appeal that you can find, then it would be helpful to us to know what they say.
I'll certainly do that, and I don't know the answer.
No. Thank you.
My learned friend's a little bit concerned about time. Under the original timetable, I was due to finish today at 12:15.
Yes.
Yesterday, I think I lost the quarter of an hour that was gained, but rather than the 1 hour 20 I would have got, but I do propose to try to keep within my time as originally scheduled, albeit I lost a bit to Mr. Metzer yesterday. So I hope to be complete by 12:15.
Well, that would be marvellous if you could manage that, Ms. Tate.
Just to recap where I was at the end of yesterday, I had reached the point where the defendant's counsel had announced that the defendants could not prove that Mrs. Serafin had been the architect who mismanaged the entrance hall work. So the truth defence at 14.9 had notionally bit the dust, but survived in a new and different form in the judgment at 198, and I showed your lordships and my lady that, where he attributed his finding to an evidential lacuna for which Mr. Serafin was to blame, and that I cited as an example of burden of proof being reversed on an allegation for which no application to amend, at least so far as we know, had been made. Now, I mentioned yesterday that when the judge detected Mr. Serafin shifting his case in cross-examination of a witness, he jumped on it straight away. And we find that passage, if we have the Respondent's bundle, at page 488. And it's electronic 2602. I don't know whether the electronic version now is available.
Did you say 488?
488, yes.
Yes, thank you.
So between F and G on 488, Mr. Serafin is cross-examining Mrs. Sipaska, one of the Pole Food investors, and at F one sees a question being put that was immediately first after we opened the company, and the judge says, you've got to keep to what your pleading is. Your pleading is, and then, because I'm not going to allow you to amend it. No, I'm not amending anything. So no shift at all allowed, and it's jumped on straight away. And while we are there, if one goes in this bit of the transcript to page 485...
Is that harking back to submissions about the pleading, amending the pleading at the start of the trial?
I think it was about, as I understand it, about at what point he was saying that he had decided he didn't wish to have her as a director of there was any application on his part to amend.
I thought there was, but we haven't got all the submissions.
No, we haven't got any submissions.
Sorry, I meant to say any. So it may have been something that had been gone over earlier in the trial.
Then at page 485, one sees at E the judge saying to him at E, that's been pointed out anyway, and we have wasted 20 minutes on this. It's all grossly unfair because you've never provided the accounts. And Mr. Serafin said, I did, my lord. And the judge says, a couple of questions down, on which account? I have still not seen proper accounts. Well, I've seen abbreviated accounts. He said, I showed, where are they? And then we go over the next page to 486. Just under E says, can I make it clear, Mr. Serafin, I'm going to ask you one last time, do you have at least for the first year of trading the full audited accounts for the company? That is to say, properly audited balance sheets with a properly audited profit and loss accounts, do you or do you not? He says, no, we never had audited accounts. The judge said, you must have done, because they were filed at Company's House. He said they were filed as unaudited, as far as I understand it. I'm not sure that says the judge, Mr. Serafin. That is what I never found any audited accounts anywhere, because I don't remember we had any auditors. And then we can jump over the interpreter. The judge says, I'm not going to allow you to ask any more questions on this theme without the documents being made available. Those documents that Mr. Serafin had just said he didn't exist. And then Mr. Serafin says, okay, and the judge says, can you ask questions on a more fruitful line, please? And Mr. Serafin says he will put a question on a different matter. And Mr. Metzer, he starts his question about a second director, because there was an issue about whether Mrs. Sipaska was going to be a second director. Mr. Metzer, just before he says, my lord, this has nothing to do with the point that Mr. Serafin said he was moving to. Mr. Serafin says it has everything to do with it. And the judge says, well, you'd better bring this to a head quickly, otherwise I'm going to get even more irritated. And then if we go to page 491, at the end of the cross-examination doesn't last very long after all that. At C on page 491, Mr. Metzer says, my lord, I don't have any re-examination, but I know my lord has done it with a previous witness, but since there is quite a lot of material in the witness statement, I'm anxious that Mr. Serafin understands that there's no challenge to any more content of the statement. If that's right, I have no re-examination. And the judge says, well, I have to consider in relation to a litigant in person where exactly we stand when cross-examination is fairly limited, but let us not worry about that now. So Mr. Serafin has been interrupted and told to stop questions unless he produces documents which he says never existed, for which there had been no application for specific disclosure and no order. And then we find, if we go to the judgment now, the criticism of him for not challenging witnesses. And it's in the judgment, it's paragraph 7 in Core Volume 1, page 316.
So sorry, page 316.
Yeah, 316, yes.
Thank you.
Paragraph 7, the judge says, after his passage on inferences drawn from absence of documentation and witnesses, the claimant did not always challenge witnesses on matters he disputed, and it was not always possible for me to remedy that omission, I make some allowance for the fact that he is unrepresented, but I must continue to bear in mind that it would be wrong and unfair for me to reject evidence of defendants' witnesses on significant matters where the basis of challenge was not put by the claimant. And that, in my submission, masks what the transcript shows was actually happening. Now, that's the end of that point. I've got one more point that I want to make on the transcript. It involves another bit of unpacking again, starting with the pleading. But it's another point concerning Mr. Lazinski, who isn't just a critical witness on Mrs. Serafin, he's also a critical witness on the allegation of refurbishment of the basement being actually done not by an independent contractor, but by his company. And this incident both reflects a closed mind, as I submit of the judge, but it also takes me into the one example I'll take of the claimant attempting in cross-examination to explore the inadequacies, in his case, of the investigative journalism by the defendants. So if we can start, as always, with the amended defence, Core Volume 2, page 433.
Electronic.
So sorry. It's the same, I think.
423.
Core Volume 2, 433. And it's...
Sorry, I've misheard you again. I thought you said 2433, but you can't.
Sorry, 433.
Thank you.
You must remember that you're all a bit
Yes,
along
got it.
the way on the sides. This is paragraph 1410 and 1411. And just to take... Oh, sorry, I maybe not... Are they switched on?
No, they don't.
Yes. I'm so sorry. I've maybe not properly...
I don't think they do anything in here anyway. They just go on to the...
Well, that used to be the case. So they have been upgraded, and the idea is they do actually
amplify yes.
for the courtroom.
Well,
Okay.
I'll
Sorry.
try and keep shouting. So I'll try and highlight just the critical bits of this particular of truth. So this is the Jazz Cafe refurbishment, and it's meaning one. The refurbishment is a complex undertaking required to be carried out by a specialist company, as the claimant himself explained in edition of POSC News. After a tender process which he ran, please note he awarded, please note he awarded, the contract for the project to a company called Antec the Builder. Antec the Builder was not a specialist company. It had previously been called Van Transport, had assets of £1, and it had previously been dormant. So, in other words, it was a corporate vehicle used by the contractors for that project. It was a previously dormant company. 411, as a director of POSC and the house manager, because he wasn't the house manager, he was chair of the house committee, in charge of the project, he should have ensured that the work was carried out, as he said it must be, by a specialist company following a tender process. We just drop down over the middle part to the last few lines. The appointment of Antec the Builder was an abuse of his position. The irresistible inference to be drawn is that his, note the his, appointment of Antec the Builder was a way of allowing the claimant to avoid revealing the amount of money he was himself receiving in respect of this project. Otherwise, it made no sense to have used a dormant company or conduct matters in the way he did. Now, if we go next to the reply, it's at page 467. It's paragraphs 10.6 and 10.7. And the reply says the claimant did not carry out the tender process for the modernisation of the Jazz Cafe. The contractor was chosen by the chairman of POSC. The contractor was a cousin of Mr. Ruman's wife. Mr. Ruman, a building surveyor, also supervised the work. And then paragraph 1411 is denied for the reasons above, and also because the whole project was documented. The documentation is not in the claimant's possession, but should be found at POSC. In particular, the vague allegation that the claimant received an amount of money in respect of this project is baseless and is denied. Now, in that volume, I invite you to go next to the witness statement of the first defendant to show the journalistic basis of this allegation as it appeared in the article, and it's at tab 14. I haven't written the page number down. Here it is. I think I found it now. Yes, sorry. It's Core Volume 2, 524. And just look at little bits of, starting at 58. The first defendant says, yet many sources explain that the claimant's activities at POSC were directed towards self-promotion and or that of his wife and family. These sources included Mr. Lazinski, a man with inside knowledge of POSC and its building activities, who spoke about the claimant's appointment of his wife as an architect when there were others more qualified. We've seen what happened with his evidence. Then going to the next and the documentary evidence obtained by Mr. Molesky and Teresa relating to the use of Antec the builder for the renovation of the Jazz Cafe. Now, as I understand that, that is the accounts showing that this was previously a van transport company and had been dormant, the corporate vehicle. The claimant made two statements in the 2006 and 2007 POSC yearbook. It's the second one that we want to focus on. A complexity of refurbishment of Jazz Cafe is a multitask project which required to be undertaken by a specialist company, and in a tender, a firm, Antec the builder, won the bid. Now, there is another version of that translation, which I will take you to in a moment, in which it's translated as the claimant saying, we appointed Antec the builder. But that is a yearbook in which he is reporting months after the appointment of the contractor, following the completion of the project, and he's reporting in his capacity as chair of the House Committee to the membership. And if we just go down to a section of 60, last few lines, where it starts, the claimant must have known, given what he wrote and the position he held. The claimant, in contrary to what he said in the POSC yearbook 2007, admits now only in the amended reply that the contractor was chosen by the chairman of POSC. The contractor was a cousin, and so on. So that was the basis of the journalistic approach to including or believing that this was appropriate to make the allegation against the claimant. If we now go to the claimant's evidence in chief in the respondent's evidence, that was, but I don't think we need to, that was to the same effect as his reply. Of course, it's in his witness statement, it's the same effect as his reply. So what we have in the bundle, of course, is his cross-examination. And if we go to the respondent's bundle at page 54, passage that starts at E, Mr. Metzer is putting to the claimant what we've just seen out of the witness statement of the first defendant. And he says, it's asserted the claimant must have known that given what he wrote and the position he held. And then the question is, you were the one determining who won the tender process. Mr. Serafin says, no, absolutely not. Then help us on this. Your report that we've just gone to, in other words, the one after the completion of the project, makes reference to a tendering process which was won by Antec. Yes. It's your report. Yes. So what do you mean by saying that? What I mean is that I was the chairman of the House Committee. I had to justify all the work that was done on the bigger projects. The committee, my committee that I was a fellow of there, didn't have any power of making any decisions. All decision was taken by executive committee, of which the chairman was a former chairman of the House Committee. And the question, but help us then, why did you report in the 2006 report published in 2007, after running a tender process, we, that's we includes you, this we is very important, selected the company Antec, the building, as a building contractor. You must have known who Antec was. And he says, no. What do you mean, no? He says, no, it was proposed by the surveyor, who was a close friend to the chairman. I was on holiday at that time, and they decided he gave the lowest price for doing the work. They decided he would be chosen. I had nothing to do with it. I didn't know the company. Actually, they ripped me off for a few £1,000s afterwards. Then they disappeared. And he produced a document for 2 years later, an invoice in which he had done some work for Antec 2 years later, and he says he didn't get paid. So why did you put in the report after running a tender process? Well, they'd done something. They compared the prices, they chose the lowest. How do you know? Because they told me this was the lowest price and this is why he chose it. So are you saying you didn't know Antec was a dormant company? Absolutely. I didn't know the man or his company or where he's coming from. Turned out he was a cousin of Mr. I think that's probably Ruman, but that was after that. If we then go to the next page, between D and F, the question is, so what were you doing writing a report where you didn't know what you were talking about? And he says, okay, if you imagine a social club, a social organisation, you've got various parts of it. The chairman of each part of it writes a report, and whatever had been in the building itself, I had to report it on it, and that was my report. If someone was culture committee chairman, reports everything that's happened at company culturally, and that was true to other parts of course. This is why I have to do it. It wasn't possible for chairman to do it, as he, as chairman now, decided about everything what's happening at POSC, because that's how it is. Now, if we go to the judgment, we can see the relevant parts of this report, which is absolutely critical to the case, in truth, and the journalistic case. And we find it in the judgment at paragraph 193. Sorry, I haven't put myself a page number. 352. Page 353. 352. 352. So this is what he wrote, which was published in January 2017. The tendering documents that he disclosed were June 2006, and he's reporting after the work is finished. And he
Which
said,
paragraph of Mr. Justice Jay's judgment?
193.
193. Forgive me. I've got it now. Thank you.
And this is in the context of disparaging the evidence of Dr. Bojanowski, which I'll come to in a moment. And what the claimant wrote, according to the translation, was during the past year, the House Division spent most of its time on works connected to the renovation of the basement, the complex refurbished of the rooms, multi-sector project, required synchronization of work by several companies. After running a tender process, we selected the company Antec. And then he goes on to say how the works were done efficiently and were completed within the timescale and the planned budget. There's then a section missing, overall cost around 200,000. And then another important point, he says here, I would like to thank all those who participated. I would like to thank also Dr. Bojanowski, whose unending help, the successful refurbishment of the basement would not be possible. So that is the after the event report. We can put that down the transcript, because so that document was that is the documents that was referred to in the first defendant's witness statement as being supporting his belief of abuse of position and lining his own pocket on contracts for refurbishment. And it's also it becomes critical on the defence of truth and the judge's finding that it was established to be true. So the claimant called, because he went first, one of the directors, executive committee members of POSC, at the time of appointment of the contractor, Dr. Bojanowski. Dr. Bojanowski had produced, the judge says otherwise, but he had indeed produced, and it was disclosed in the supplemental list of the claimant, 23 pages of the tender form and schedules for the work. He gave clear evidence, which we'll look at in a moment, on days 2 and 3. His evidence in chief and his cross-examination were to the same effect as the claimant himself had testified. So if we go to page 238,
Is this the main bundle?
this is the respondent's bundle. Yes.
EB number as well.
I don't think he does. I think he says the number is the same.
It's different. It's on the report.
He said yesterday. So this is Mr. Bojanowski being cross-examined. Perhaps we need to start, sorry, at the very bottom of page 237, cross-examined by Mr. Metzer. So if the claimant is House Committee Chair, how could it be that a dormant company, Antec, which is formerly a van transport company, won a tender for a major renovation work costing around £250,000? Mr. Bojanowski says, I don't believe Mr. Serafin was present at that time. The chairman of the committee had previously been chair of the House Committee, and there was a tendering process where documents were sent out to various. Who did the tendering? Dr. Lalko. Lalko was the chair of the executive committee. And if we then go down to F, the question, so it's inconceivable, isn't it, that the claimant would not be aware that Antec was dormant, which presumably means aware at the time of his appointment. Dr. Bojanowski says, no, he wouldn't have known about it. Well, who would then? The tendering process was run by Dr. Lalko. It went through committee, I know, because I insisted on health and safety questions being put in there, and I found no reason to exclude them. Question just helped me on this, even if I'm excusing the claimant for a moment. In terms of POSC reputation, how could a dormant company win a tender? How could that happen? And he explains they didn't do all the other contractors. It's run by our consultant surveyor. It's put to him that it's a bit of a shower, which is rather different to a piece of non-arm's length dishonesty. That's rather more an allegation of incompetence. And the answer, I have no idea. I would have thought Dr. Lalko, I think checks are normally made on companies. I understood that people coming over from Poland, workers, which I don't know. Then the judge between F and G asks, do you have personal knowledge of whether the claimant as House Committee Chair played a role in the tendering process, or are you relying on your opinion or what you may have been told by others? He replies, I don't think he was present at the meeting. And the judge says, but do you know, were you present? I was present at that meeting. I don't remember him being present there. I think one has to go through the records of who was present at the meeting and the tender process. And the judge says, but he was entitled to be present at the meeting. Yes, I don't think he was. I can't remember him speaking up. And of course, we'd heard the evidence of the claimant who said, I was on holiday at the time of the tendering process. Then Mr. Metzer says, so we've heard nothing to suggest, but your memory may be that you simply can't remember him being there, but it was certainly, a bit before that. Between B and C, Mr. Metzer says, I think we can cut through this. I don't think it's part of the claimant's case to say that he wasn't there. Well, the claimant, of course, had given evidence that he wasn't there and that he was on holiday. Then, if we go down to, I think we can probably leave it there. It was a time when we've heard nothing to suggest, but in your memory, you simply can't remember him being there, but it was certainly a time when he's very actively involved. Yes, and that's all, really, all they have. Now, that should have been the end of that part of the particulars of truth, because unless they could prove that Mr. Bojanowski had got it wrong or was telling a lie, that is the end of it. But it doesn't make it the end of the reasonable journalism and using that as a basis. So then have to go, so we then, later that day, after two more witnesses are called by the claimant, the third defendant and then the first defendant goes into the witness box, and the Antec point then starts again at 363 of Respondent's bundle. Go to between E and F, and Mr. Serafin asks the first defendant, okay, final point, will you help me with something? As a journalist, it'd be fair to me to say you have a good grasp of language. Yes. And the witness says, but what's the question? And the judge says, so he has a good grasp of the language. Well, so. He asks him then to go to the yearbook entry that we saw at paragraph 193 of the judgment, and you will record it from the refurbishment. And the judge is clarifying over the page. B, this is the report, the committee house report. Yes, it's my report to the annual board of POSC. And then the question that's popped just above F, Mr. Serafin says to the witness, few times in this trial, my use of the word we has, judge, no, ask a question, do not launch into a speech. What is the question about it? And the question, he says, is would it be fair that the word we could have been used not necessarily to show that I, the person involved in, probably means the Antec, but instead as a universal term for Polish community, which I think probably may be a reference to POSC. Now, if the witness had said, yes, we could perfectly well mean POSC or your committee or whatever, that would have been a killer point on why they made this allegation against him. So one waits with bated breath to see whether there would be a realistic answer from the witness, and the judge jumps in before the witness is allowed to speak, and the judge says, apart from the fact that you say twice here, I would like to thank, and that was the bit at the end of the yearbook where he was thanking those who worked on the project. Mr. Serafin said, yes, I thank everybody, yes, personally. And the judge says, what sort of question is that? I know you are trying to distance yourself from this document, but your fingerprints are all over it. Yes, I'm not questioning that I wrote this. You wrote it, yes. And the judge says, yes. And you, therefore, were part of the process that selected Antec, the dormant company. So this is a hopeless line of questioning. The more you try and distance yourself from this, the worse it gets from your perspective. And then he says, is there a question you want to ask? Of course, he had asked a question, but he had not been allowed to do so. Now, so the judge, after hearing the evidence from Dr. Bojanowski saying he did not select that Mr. Serafin didn't select Antec. He wouldn't have known he was a dormant company. He wasn't at the meeting. He was chosen by Dr. Lalko. The judge is already indicating that he has a closed mind on this issue. He's going to disregard the first-hand evidence of Dr. Bojanowski that Antec was not selected by the claimant. So apart from the word "we" in the yearbook, the defendants called no evidence of the claimant having selected Antec. They did call Mr. Lozinski, who we've already seen, on that issue. He gave no first-hand evidence as to how and by whom Antec was selected. He had merely, after hearing the announcement of the company at an annual general meeting, looked up Antec at Companies House and found it to be a previously dormant company. Now, in order to see what happened in the end, we need to go to the judgment to see whether the appearance of the closed mind then feeds through and plays out into his findings. And if we go to the judgment at Core Volume 1, page 351, so this is meaning 1. I'm going to try and skip through it as economically as possible. It's also mixed in with the Mrs. Serafin point at the entrance hall, and I'll stay off those. So it starts at the whole section is 185 to the conclusion that the first meaning is true at 199. And the judge identifies what the allegation is at 185. The claimant abused his position in POSC in order to award himself or his company profitable contracts for renovation or maintenance work. And he says, in my opinion, the allegation transcends the serious harm threshold. And then in 186, just the second sentence, everything hinges on the significant contract for the renovation of the Jazz Cafe. 187, he refers to the claimant's own evidence, and the last sentence of 187, the judge records on his account, the builder who renovated was chosen by the chairman of POSC. At 188, he notes the key witness is Dr. Bojanowski, who, as a witness statement, the judge thinks is opinionated and lacking in objectivity, but in many ways came across as a reasonable measured witness. And then the last two sentences, according to his witness statement, the contractor who was engaged to renovate Antec went through a tendering process, and I remember checking the safety records. He states that he still has some tendering documents, but did not provide these for my consideration. He did, in fact, do so. They were annexed to his second witness statement, and the judge did the examination in chief of him over his 3 witness statements. So he produced 23 pages or more of tendering documents. Paragraph 189, in the oral evidence, Dr. Bojanowski said that, and then just going to the last line, although the chair of the executive committee, Dr. Lalko, examined the tendering documents, he claimed that the claimant would not have known about Antec. And then 190, the defendant's key witness on this issue was Mr. Lozinski. And the judge says he was on the House committee at the relevant time. Actually, Mr. Lozinski did not give evidence. He was on the House committee at the relevant time. He only knew about this. He'd been on it previously, only knew about this from the AGM announcement. So Mr. Lozinski, we're then told, had an immensely distinguished career in structural and civil engineering. And the judge perfectly understands what the evidence is that Mr. Lozinski's given, which is this. The name of the company was announced at the meeting, that's the AGM. I then looked into the company records, and this company had no experience in construction. And then the judge at 192 said that is true if you look at what was at the company's house. He then was then seeing the passage where the judge refers to the yearbook and says Dr. Bojanowski's assertion that the claimant would not have known about Antec is belied by the following extract, written months later. And then 194, under cross-examination, the claimant said he did not know who Antec, the builder, was, or that it had been a dormant company, and sought to distance himself from the POSC yearbook entry. This was wholly unconvincing. In my judgment, it's clear the claimant was heavily involved in the instruction and engagement of Antec, the builder. And then Dr. Bojanowski is accused of trying to protect the claimant in a self-serving manner because of the effusive thanks to him for his work on the project at the end of the the yearbook. And then the startling statement, last sentence of paragraph 195, I prefer Mr. Lazinski's evidence on this subject. Mr. Lazinski given no evidence about how Antec was selected. He had no first-hand knowledge. Then at 196, very important findings, the judge says I have to see what inferences are to be drawn from the evidential shards. He says very generously to the claimant, I cannot conclude the renovation works were in fact carried out by the claimant or his company. And then if one goes down to after the reference to 304,000, he goes on, but it is difficult to avoid the conclusion that this was not an arm's length relationship with POSC. In my judgment, the claimant's lies and obfuscations in relation to Antec drive me to conclude that he did benefit in some way from the engagement of this company in relation to which he was instrumental. I accept Mr. Lazinski's evidence that the claimant got his choice through the House Committee without proper debate, and his allies on the executive were less than punctilious. He said no such evidence, and then the conclusion is that this very serious meaning of abusing his position in order to line his own pocket is proved to be substantially true. So that is, I wanted to unpack that one because it shows the closed mind. It's a critical issue that where the attempt to cross-examine was stymied, that went not only to truth, but also went back to journalism. Now, time does not permit me to take the court to the unfolding of his attempts to cross-examine on the list of things that the Court of Appeal identified, to which I added Mr. Legeza. But just to invite you to read them at greater leisure, just to remind that the list in the Court of Appeal was the Court of Appeal paragraphs 73 to 80, to which one adds Mr. Legeza. The third defendant's evidence, doesn't go on very long, is at the Respondent's Bundle 316 to, I've written 238, it must be 338, I think. And then the first defendant's follows straight after. So I'm going to put aside the Respondent's Bundle, and my proposal now is to show how the judge at trial dealt with the Section 4 defence, then how the Court of Appeal, by contrast, dealt with it, and when I'm dealing with the Court of Appeal, that will be the vehicle for my submissions on Section 4.
Could I just ask a quick question? Yes. Sorry, before we leave this topic, are you saying this is a case of apparent bias or actual bias?
I think I have to say exactly that.
Okay.
Could I, if you're leaving the unfair or otherwise trial point, I wonder whether I could ask you to clarify my mind about what the Court of Appeal's actual order was. Could we go first to paragraph 102 of the Court of Appeal's judgment, which is at 297? Now, this is the conclusion reached before the court has dealt with unfair judicial treatment. And before that is addressed, the Court of Appeal concludes that your client is entitled to proper vindication and compensatory damages in respect of the unproven Colby House allegations, 8 to 13, and the allegation number 4, in respect of which they have reversed the judge's conclusion. So that's what they get to at that point. Then, of course, there's an extensive analysis of allegedly unfair judicial treatment. What is the conclusion that the Court of Appeal gets from that, Miss Page, in terms of relief?
What it became the subject of submissions after they produced their draft judgment, and the outcome was that they entered judgment for the claimant, damages to be assessed by a different judge of the Media Communications list.
Damages on what?
Damages on imputation 13.4. Now,
Just on 4,
just on that imputation.
not on the Colby House unproved ones?
Oh, sorry, it would have been on the Colby House unproved. I'm so sorry.
We must get this clear. Do you
Yes.
mind my saying that?
No, of course not. No, absolutely. No, everything, assessment of damage on everything that was unproved, which is what was unproved on the findings of the judge, and what was untrue, 13.4, on the finding of the Court of Appeal.
But you've just spent 20 minutes trying to persuade us that the conclusion on 1 was extremely unfair. But you're not getting damages on that, and you're not getting a retrial on that. Is that the correct analysis of the Court of Appeal's disposal?
This is a very, very difficult question. Yes, it is a very, very difficult question, because he will go to an assessment of damages with these things being held against him on damages. But what is the alternative is a retrial in which one goes through it all again. Parties who've got no money, who are exhausted and stressed out on both sides by this, because they've had their day in court and it's just been wasted.
But, I mean, that's a practical point. I'm trying to look at it logically.
Yes, well, logically...
If the trial was unfair, none of this can stand, Miss Page. And can we look at the Court of Appeal's order,
270.
which we've got at 269.
It's paragraph 5. The order.
1, there be judgment for the appellant. 2, the orders of Mr. Justice J be set aside. 5, the matter shall be remitted for an assessment of quantum. Now, I don't see anything there that limits the damages to the Colby House and the 4th meaning. So, what's this order saying? What is its effect?
Well, I can only say for what was at the understanding on this side was that the findings of the judge that were not assailed in the Court of Appeal, because only one of them was selected, because its unfair trial was to cover the whole thing. The outcome here would be that he would go to an assessment of damages to recover only in respect of what the judge had acquitted him of and what the Court of Appeal had acquitted him of. In other words, it was an attempt at a proportionate approach to the appeal, but perhaps in the benefit of hindsight, it should have been a more radical approach in the Court of Appeal, but that's not where we are today.
Well, A, it's illogical. And if you're right about unfair trial, it's illogical. And B, it's not what this order says.
Well, I think that's how the order was understood.
Well, maybe. Well, there we are. Thank you very much indeed.
May I ask, what are you asking us to do if we dismiss the appeal?
We rather avoided that in our case, waiting to see really what the judgment, what the decision is, and to make a judgment then. As my learned friend said, the idea of a retrial is a nightmare. The idea of an assessment of damages doesn't do justice to either side. Sorry, just, what does one do? I mean, presumably the logical thing is there'll have to be a retrial. There should be a retrial. We don't formally ask for a retrial. We would have gone along with the compromise position, but which was in any event not acceptable.
Did you ask the Court of Appeal for a full retrial? Because the Court of Appeal's conclusion after the unfair trial analysis is that ground, was it 5, I think, is upheld.
Yes.
Now, I'm not sure, I haven't been back to look at that ground, but I'm not sure whether there was what the Court of Appeal thought it was ruling on in terms of what the parties came to the Court of Appeal to ask for.
Miss Marzik was...
I can clarify the position of the appellants if you wish.
Told by Miss Marzik that the Court of Appeal asked for submissions afterwards, and in her submissions she said the logic was a retrial.
But sometimes when the Court of Appeal is faced with this situation, it sets out the facts which are not to be challenged thereafter, if there's this sort of hearing, so they can't be reopened. And sometimes it says that they can be reopened. Yes. So there was a way out.
There wasn't a ruling.
Well, speaking for myself, if you're right about unfair trial, there is simply no terra firma in Mr. Justice Jay's judgment at all. And you can't say, well, we'll keep that. And not, you could as a compromise, and the word compromise, goodness, that comes to mind. But we've got to be logical about it, Miss Page.
Indeed. The logic is a retrial.
Very well.
Miss Page, no one would have, no defamation lawyer would understand paragraph 5 of the order as reopening questions of truth, would they?
No.
As I see it, what the Court of Appeal ordered, in order to understand what they actually did, because there's no cross appeal, I think, against the Court of Appeal's order to us, is there? No. So what they appear to have done is to simply have reopened the quantification of damages question, and one assumes on the basis of those findings of proof of truth or falsity, i.e. failure to prove truth, which survive from the combined analysis of the judge and the Court of Appeal.
So where the judge had said, in the light of my findings, I would have found his reputation shot to pieces and wouldn't have given him any damages, the Court of Appeal said, well, the landscape's different now because we've reversed.
I understand that reopens, if you like, issue B.
Yes.
But only as a quantum question.
As only as a quantum question, yes.
But when Mr. Price says, well, shot to pieces, we've still got a meaning 6. If there's been an unfair trial,
there is no meaning 6.
There's no meaning 6 established.
Yes.
Very well.
Well, if at some stage you can just give me the page numbers for what you were asking for in the Court of Appeal, it might help us understand how to reconcile the Court of Appeal upholding your ground of unfair trial, but not reflecting it in the order.
We'll send in the written submissions that were made after.
Well, and also I'm more interested in what most of the appeals says and what everybody was asking for at the beginning of the appeal rather than in submissions after the judge. But they'd all be helpful.
Yes.
Then Justice Jay's orders were set aside without qualification. It's orders that count rather than judgments.
Yeah.
Ms. Marzik tells me that she asked for the Court of Appeal to set aside the judgment. Of course, one sets aside orders, not judgments. That didn't prevail. It wasn't, as it were, a setting aside of the judgment. Now, on that note where
Yeah, I mean, it's a, you know, as it were, we can't have a curate's egg. You know, if a judgment is tainted by bias, that's an end of it, I would have thought.
Yes.
I turn now to section 4, and I wanted to do it in this way. First of all, to look at how the judge dealt with it, and then how the Court of Appeal did it, and to make the Court of Appeal the basis for my submissions on the approach in principle. In the judge's judgment, the section starts at paragraph 308, it's Core Volume 1, 372. The place I would invite you to start, he sets out the Act, he sets out the judgment of Mr. Justice Warby in Economou. This is before the Court of Appeal. In Economou, he notes that it's on the route to the Court of Appeal. And I wanted to start and make a few observations from the passage starting at paragraph 314. So he starts off with the evidence of the defendants, who, of course, were the critical evidence, together with such documentation as they might have produced on reasonable journalism, if I may put it that way. And he says that these defendants provided with lengthy witness statements, each was cross-examined. And then he makes this observation that the claimant had difficulty with witnesses of this caliber. And I invite you to note that, having regard to the attempts that he made to make his case in cross-examination. But then by contrast, we have the first defendant with his Balliol Doctor of Philosophy and so on. At 317, he notes that Novi Tras is a publication which prides itself in its investigative reporting. So it's not putting itself across as a sort of blog, a homemade blog or something. It's a proper journalistic effort. At 318, he notes that it starts with an anonymous email in February 2014 from employees at Colby House. That email was produced, so that is source document 1, if you like. He then notes at 319, the first and third defendants met their confidential sources on the 12th of September 2015. Now, there is a passage when, in the cross-examination, the first defendant, when the claimant asks him, how do you know that you were meeting the same person as sent the anonymous email? But unfortunately, the answer gets cut across, not by the judge, I have to say, and never gets answered. Anyway, so there's a meeting on the 12th of September 2015, so a long time afterwards, and much closer to the article. And that was apparently transcribed, and that becomes source document 2. And the judge notes what the gist of that meeting was. Now, those were the only 2 records produced by the defendants of exchanges with those they claimed to be sources. They produced an email, anonymous email, and a meeting of said to be Colby House staff, transcribed, and a note produced. There are no notes of talking to anybody else as sources for this article. If we then go down to paragraph 321, the judge notes that there was a further meeting on the 10th of October, and he notes, without comment, I do not understand this meeting to have been tape recorded. I have not seen any notes. And the employees gave further information. So the paper trail of investigative journalism, of which this publication prides itself, ends already by that point. At paragraph 322, he notes that the first and third defendants felt that this was genuine, reliable evidence. Colby House is a Polish charity, largely funded by charitable donations, and therefore of particular interest to readers. The defendants were minded to write a piece about the claimant, one notes, not about running of charities, but about the claimant. But before doing so, went back to earlier articles and letters published by the newspaper which related to them. So they relied on their own previous publications. These aren't independent sources. These were, before the judge, mainly in Polish and untranslated, so far as we can tell, and so far as we can tell, not remotely comparable to the article. And he summarizes the sort of things they cover at 323. Then he goes to, at 325, to their final decision to publish and reproduces what we see in their witness statements. We then jump over their witness statements to paragraph 326, and the judge notes the reasons for not contacting the claimant before the article was published were that he had not complained about previous articles and letters published in Nowy Czas, which the judge had largely seen only in Polish. He did not believe that he would respond for comment, and that the third defendant has been warned that the claimant was a violent and cooperative liar. Now, when one reads the cross-examination of the first defendant, he gives various answers as to why he didn't. He's asked about why he didn't make contact, and he says nothing there about fearing for his safety or anything of that kind. And anyway, just write the man a letter or ask the POSC management or the Colby House management or other third parties. If we then go over to paragraph 330 on the next page, the judge says this is only criticism of it, but he nonetheless he manages to pull back for them. There were two possible lacunae in the evidence of the defendants, which the claimant did not appear effectively to exploit. I do not believe the transcript of the meeting with the employees in September 2015 reveals that they complained of the claimant's access to confidential information about residents, which was a particularly nasty allegation in the article. Secondly, there is an absence of evidence in relation to the unnecessary replacement of bathroom furniture. As for the bathroom furniture, there was no cross-examination about this. And then he says, and the issue may well have been covered either in the October 2015 meeting, which has not been transcribed, or in the various emails, some of which have not been translated. In all the circumstances, I have to conclude that the defendants did have an evidential basis for their imputation that the claimant replaced bathrooms unnecessarily. The Court of Appeal queried, and I think I'll ask Mr. Metzer whether this was a typo. Did he mean to say did not have an evidential basis? And I think Mr. Metzer's position on reflection was that it wasn't a typo. Then he goes on to say it's for the court to decide whether publication is in the public interest. So he's finished with the journalistic investigation, and he goes straight to his conclusion without passing go. I'm completely satisfied that it was in the public interest for the defendants to publish an article about the claimant's fitness or otherwise to be involved in a charitable institution, Colby House, and the claimant effectively conceded as much. So he doesn't go through the methodology of Section 4. He is the one who starts off the idea that we're looking at in the public interest rather than on a matter of public interest and whether the defendant reasonably believed it was in the public interest. He declares it in the public interest as his conclusion. He then, at 335, he goes on to 41b, more analysis, little analysis in very broad terms, where he says it requires the publisher reasonably to believe the statement is in the public interest. It means the belief must be reasonable, and that she or it took reasonable steps to ascertain the reliability and credibility of the substantive content. In other words, the publisher must undertake reasonable inquiries, come to a reasonable conclusion, and that any sources are reliable, credible, and where appropriate, obtain the target's version before publication. And then at 337, his conclusion is, I am satisfied these defendants did undertake reasonable inquiry. Indeed, I'd go further. I think they applied rigorous objective journalist standards in the context of a piece which cried out to be published, and so on. So although he knows what he's telling himself, he's announcing what he needs to be looking at, he just reaches a conclusion with no analysis at all. And then at 339, the defence of public interest succeeds in relation to the entirety of the words complained of. There's been no analysis of the public interest, there's been no analysis of the, no review of the reasonable belief. What he has done is he has rubber-stamped the journalist's own judgments and so on, which is precisely what Mr. Price is asking this court to find should be the correct approach.
Do you challenge paragraph 335 as an albeit necessarily summary statement of the relevant legal principles? And if so, how? I think I'm reading what you're saying as really a sort of perversity allocation, that if he applied that, it's hard to see how he actually applies those standards in practice. But do tell me if you do challenge anything in 335.
As will become apparent when we go to the Court of Appeal judgment, one has to be careful about not using words must here, what journalists must do. You can say the court must look at all the circumstances or must disregard an omission to verify, but there are no musts about this so far as journalism is concerned. It is elastic and flexible and pragmatic. And in each case depends on its facts. If one takes, for example, the Jamil case where the fact that was being adopted as true there was that the claimant's bank accounts were being monitored by the Saudi Arabian authorities. So long as they were satisfied on that, they did not have to inquire into or verify whether or not the Saudi authorities had reasonable grounds to suspect. So at each case, you have to look at what is being adopted by the article, and it's what is being adopted as true, unless it is common ground, as it was in Flood. It was common ground that the officer was under investigation. And that was the only, so long as they were satisfied about that, and that was the public interest in the article, they didn't adopt it, they didn't embellish and assert that there was a reasonable basis for it, therefore they didn't have to verify it. Now here, where you have what Lord Mance referred to as out-and-out allegations, then that is what's been adopted, that is what is being asserted to be true. And the public interest is on the premise that they are or may be true. And that is where the obligation comes for the journalist to make sure they've done their best to get the facts right, even if they could never prove it. Because it's got no value to the public. There is no public interest in sloppy journalists just chucking damaging things out into the public domain and causing serious harm to people's reputation without taking proper care. If we now go to the Court of Appeal judgment, the Court of Appeal, by contrast, does the analysis that the judge should have done. And if we go to the relevant part, I want to start at paragraph 34. It's called Volume 1, page 282. Let's just check that one. And I want to just get a light on a few points and respond to a few of Mr. Price's points that he made. It's a small point, but starting with paragraph 34, the reference to the CJEU, of course it's not the CJEU. There were 3 counsel in front of the Court of Appeal who one would have thought might, in the corrections, have got that corrected. Then we go to paragraph 36, where they refer to the well-known checklist, and at the end of paragraph 36 they say the Reynolds checklist is still relevant under section 4. Now,
well, you've missed out the middle sentence. In Reynolds, Lord Nichols set out a well-known checklist for use when determining whether the defendant reasonably believed.
I hadn't
Well,
spotted.
you can't defend that, Miss Page, can you?
No. Oh, I see, whether the defendant reasonably believed. Well, no, I'm about to criticise this paragraph.
Oh, well, go ahead.
Yes. Which is this, that the Reynolds factors are not a checklist. The court has to look at all relevant circumstances. There's no reason why there should not be a corpus of authorities which identify what are relevant factors, but it's not a shopping list. It's not something that journalists have to go through when they're writing an article. But what is clear, that the courts are left by section 4 to develop what they think are the correct points of reference. So they have to be factors of potential relevance depending on the facts. So if the courts decided that journalists were only had a reasonable belief in the public interest if they wore suits when they interviewed their sources, that would be like the dismissal of teachers for having red hair, as cited by Lord Green in Wednesbury. But all of the factors that Lord Nichols promulgated as examples of what may be relevant clearly are all relevant, and it's never been suggested that these aren't perfectly proper reference points. And can I then just, there's give a reference to the fact that Lord Nichols also said, it's not cited. But can I just read what Lord Nichols said about it? It's the common law does not seek to set a higher standard than that of responsible journalism, a standard the media themselves espouse. So that is the starting point. And overnight you will have received, I think, the impress, the reference to
Page 202.
that is page 202
Between
between E and F of Reynolds.
By 202, you mean the paper number, presumably, the paper page.
Paper page, yes. So
It's not in the bundle.
That bit is not in the bundle.
It's remnants.
It's remnants, yes. Overnight, my learned friend provided the impress equivalent of the IPSO code. And can I just invite attention to some parts of that? At the bottom of after about 10 lines, the sentence on the left, a public interest means the public has a legitimate stake in a story because of the contribution it makes to a matter of importance to society. And they suggest such interests include and not limited to revelation or discussion of matters such as serious incompetence or unethical behaviour that affects the public, putting the record straight where there's been misleading of the public on a matter of public importance, revealing that a person or organisation may be failing to comply with any legal obligation they have, proper administration of government, and so on. And then over the top of the third column, this is following provisions apply where a publisher is about to undertake an action they think would otherwise breach the code, but which they believe they have a public interest justification. The action might be a particular method of news gathering or publication of an item of content. Before undertaking the action, the publisher should, where practicable, make a contemporaneous note which establishes why they believe that the action is in the public interest. They could not have achieved the same result using measures that are compliant with the code. The action is likely to achieve the desired outcome, and any likely harm caused by the action does not outweigh the public interest in the action. Just to remind the court, following the Leveson inquiry and report, the Crime and Courts Act 2013, which I think got royal assent on the same day as the Defamation Act 2013, introduced the concept of an approved regulator, defined in section 42.2 as a body recognised as a regulator of relevant publishers. Section 42.3 states that the body must be recognised by a body established by royal charter for the purpose of carrying on recognition activities. On the 3rd of November 2014, the Press Recognition Panel was established by royal charter for this purpose, and on 25th of October 2016, the Press Recognition Panel granted recognition to Impress. No other press regulator has been given recognition.
I'm sorry, what act was that?
It was the Crime and Courts Act 2013.
Thank you.
And it's section 42, yes. 2 and 3.
And the date when Impress was recognised by the PRP was?
25th of October 2016. Thank you. Can I invite you to go over the page to paragraph 41. At paragraph 41, there's a reference to the Court of Appeal in Economy confirming that the two tests are not materially different. Now, that isn't actually quite correct as to what the Court of Appeal said. Lady Justice Sharp, as she then was, and we see it in paragraph 43, puts it slightly differently to that. She says the statutory formulation in 4.1 obviously directs attention to the publisher's belief that publishing the statement complained of is in the public interest, whereas the Reynolds defence focused on the responsibility of the publisher's conduct. Nonetheless, it seems to me it could not sensibly be suggested that the rationale for the Reynolds defence and for the public interest defence are materially different. She is acknowledging the differences in approach. What she is saying is not materially different, is not the test, but the rationale for the test. And we submit this is an exemplary, carefully, thoughtful passage, carefully written passage. And she goes on to say, and or that the principles that undermine the Reynolds defence, which sought to hold a fair balance between freedom of expression on matters of public interest and the reputation of individuals, are not also relevant. And that is the point. It's relevance. It's not must or requirements. It's relevant. Then at paragraph 44, the Court of Appeal says the defence is a form of qualified privilege. And Mr. Price makes the entirely fair point that it's been acknowledged that it is jurisprudentially different. Reynolds was jurisprudentially different to creature, to qualified privilege at common law. However, this is only a point of labelling, and one must remember that the statutes of 1996 and 2013 still have extensive provisions. They were updated in 2013, providing reporting defences, so neutral reportage defences for fair and accurate reports, providing they're in the public interest, and they are still called qualified privilege. So it's not really particularly heinous to refer to it still as qualified privilege.
What is the jurisprudential distinction?
A Section 4 defence, or a Reynolds privilege, it used to be called. Since it's not an absolute immunity, there's no reason not to call it qualified, but for some reason the courts have started to try to avoid using that expression in order not to suggest that it is in some way born out of the old duty interest, because when Reynolds evolved in the early days, there was a suggestion that there was a duty to publish and interest to receive, and that duty interest language is gone. It's not helpful. And there's no need for malice, of course, as well, although malice obviously would defeat it as a rebuttal. Then they're quoting Lady Justice Sharp again in paragraph 44, and if I can just invite you to go on page 285 to pick it up halfway through her passage where she says, "In my judgment, all the circumstances of the case must include the sort of factors carefully identified by the judge, including, importantly, the particular role of the defendant in question. The statute could have made reference to the Reynolds factors. It did not do so. That is not to say, however, that the matters identified in the non-exhaustive checklist may not be relevant to the outcome of a public interest defence, or that on the facts of the individual case, the failure to comply with one or some of the factors may not tell decisively against a defendant."
I mean, that was the principal point, I think, that Mr. Price was anxious to emphasise yesterday, and I presume it's not in dispute.
And then we don't have Lady Justice Sharp at 111, but can I just give the reference to her at 111? It is in the authority, I don't think we need to look it up, authorities bundle 172, electronic bundle 934. She refers, just to complete her, she says, "I quite accept that an appropriate..."
I'm sorry, I haven't...
I'm sorry, I was
page.
suggesting one didn't need to follow, to look it up. It's a primary volume, authorities 172, electronic 934. It's paragraph 111. Just this passage, she says, "I quite accept that an appropriate balance between the rights engaged would not be struck if the bar of reasonable belief was set too low, or if all those who took part in a particular publication were able to look to the other participants to fulfill what they would otherwise reasonably be expected to do given their particular role in the process." And that's, of course, because here it was the contributor in Economy, not the newspaper. But it's really the first part of that the appropriate balance would not be struck if the bar of reasonable belief was set too low. And I want to say something in a moment about the balancing of the convention rights. just before we get there, at paragraph 45, going back to the Court of Appeal judgment, the Court of Appeal notes that she referred to the two-stage test, and then they say whether the subject matter of the article was a matter of public interest, whether the steps taken to gather and publish the information were responsible. And I know that word responsible jars for Mr. Price and for the MLA interveners as well. Can I just suggest that it is a shorthand expression for standards of journalism? It has no substantive content other than what it gives one. It's a convenient way. It is not a point of substance to refer to it as responsible journalism. The converse, after all, is irresponsible journalism, and presumably that is not being advanced as being the test. In paragraph 47, the passage criticised by Mr. Price in relation to the Article 8 right, there's no reference here, it is correct, to Article 10, and what is, there is at the end of that paragraph, and the criticism of the Section 4 defence needs to be confined to the circumstances necessary to protect Article 10 rights. There are two possible scenarios so far as Article 8 and Article 10 are concerned, and they were dealt with by Mr. Justice Warby in Yo, which was a case of a politician, and we give a reference to the passage in our case at paragraph 12. In short, what he says, and I respectfully adopt this, if Article 8 is not in play, Article 10 has primacy. Article 10 convention right is there, and necessity and proportionality have to be met on any restrictions on interference with that right. In cases unlike Yo, but a case like, we suggest this, where Article 8 is engaged, then one has to do the Re-S methodology, because neither right can be interfered with other than by applying the necessity and proportionality test. So the Court of Appeal is right, but they've explained it perhaps not very well. Then at paragraph...
The first sentence of 47. When determining the issue whether defamatory material is published in the public interest under Section 4, the public interest publication is to be balanced with the fact that an individual's Article 8 right to reputation will be breached by the publication of unproven allegations without a remedy.
I don't stand by breached. Engaged. It may be breached.
Well, the courts must see to it that it's not breached.
Precisely, yes.
Well, without a remedy, there's always a remedy for a breach of Article 8.
No, there isn't, because the Article 10, the balancing may result in the court concluding that the public interest is better served by the publication than by the restraint on the publication.
Of course. Then there won't be a breach of Article 8, will there?
No, it wouldn't be a breach.
No.
The Article 8 right would be engaged, but the balance would have tilted.
Of course.
Yeah, so I accept the criticism of the way that's put, but it's still an important point. And the point is that Parliament has not set the balance. The court set the balance. The balance depends on the facts and the circumstances. If it is an Article 8 case, that is a relevant circumstance that the court must take into account. In fact, is required to do by the Human Rights Act.
Thank you.
Yes, I suppose you could say that it's difficult to envisage a situation where Section 4 is in play, where Article 8.1 isn't engaged. There's an interference with a person's right to respect for their reputation. But under Article 8.2, the interference can be justified where necessary to protect the rights of others or the public interest, effectively. And so Article 10 comes in there. the Article 10 rights of the publisher.
Both rights are qualified rights.
Yes, right.
And they're both qualified, they both qualify each other if they are both engaged.
As
If they're not engaged, then Article 10 is an unqualified.
Yes. So, and in the last sentence where it said that Section 4 needs to be confined to the circumstances necessary to protect Article 10 rights, if you unpack it, thinking about Article 8.2, you're really thinking in terms of a proportionality analysis, I think.
the Monaco case.
Yes, indeed. There's one other criticism I accept, which I passed over in the beginning of paragraph 47, when determining the issue whether defamatory material is published in the public interest. One's really got to stick to what the Section 4, accept that wording is. And then at 48, they say, when considering whether or not an article is in the public interest. Again, it could have been better worded, but it does not infect their conclusion. It's a presentation that doesn't quite get it spot on. Then over the page...
So really, Lady Justice Sharp is spot on, I think, isn't she, in saying it's a question of balancing the right to protection of a person's reputation on the one hand and the right to freedom of expression on the other hand, in a way which is convention compliant.
Precisely.
And so Section 4 has to be applied with that in mind.
Yes.
Because otherwise the court is being entrusted with ensuring that convention rights are respected.
There will be cases where the public interest is enormous and the potential harm to reputation not so enormous. And so the threshold, the bar for the responsible journalism test to succeed may be low. Other cases where the potential harm to reputation is enormous, the public interest is pretty minimal, and the court will scrutinise much more carefully. So there is no set level for this, and every case the balancing has to be done on its facts. Then turning then to the analysis at...
But are you saying that the balancing exercise is sort of an additional exercise which the court has to perform whenever a Section 4 defence is raised? Or are you saying that Section 4 is Parliament's attempt to achieve a balancing mechanism in a situation where, generally speaking, Article 8 and Article 10 are both going to be engaged, and therefore the references to public interest and one's perception of its ambit and references to what is or isn't reasonable has to be read and interpreted and applied with that in mind?
Except I respectfully adopt the latter.
Yes.
What Parliament has done is provided, and my Lord used the expression mechanism, it's provided the machinery. It hasn't decided how the machinery will be operated other than which order you do things and what you have to do. But it's all against the backcloth of the rights involved, the importance of freedom of expression, the importance of protection of reputation, and that will differ in every case. It is totally a neutral as to where the balance lies in any particular situation, and the courts, by the removal of the Reynolds factors, Parliament has in effect widened the discretion to the court and trusted the court, in the light of the way in which the Reynolds jurisprudence was developed, to bring to bear relevant, appropriate considerations according to the facts of the case.
Yes, I mean, the width of the language of a reasonable belief and attaching such weight to editorial judgment as the court considers appropriate and having regard to all the circumstances it's all language which suggests that Parliament isn't really attempting to be prescriptive, but is setting up a flexible framework for the courts then to apply.
There's one point I should mention on that may not have been sort of picked up. But when the section says the court must have regard to all the circumstances, that isn't a reference back to section 4.1b, it's a reference back to section 4.1. So it covers the public interest as well. Just returning to the Court of Appeal, because I've got another 5 minutes. I submit that paragraphs, the analysis at 51 on the public interest, and the conclusion is totally justified and appropriate. It's right and it's open to them, and they standing in for doing the job that the judge did not do, and saying the article was not about how POSC and Colby House were run as charities, could not be said materially to have contributed to any debate in the Polish community. Just pausing there, my learned friend in his case says, contributed to a debate, general interest, is for the misuse of private information. But that's not so. That's the Strasbourg jurisprudence on defamation. It's received in Bladit, Trump, so one sees in Axel Springer. We've made the references in our case. Rather, the article was aimed at the narrower target of the claimant's personal life, mores, and conduct as a contractor, supplier, and volunteer. The gravamen of his complaint is what the article says about him personally in these capacities. And you'll recall that the article and the large picture of him, this is targeting him. The idea that can be of public interest because he was in some managerial position, the whole point is he was not the manager. He was the handyman or the maintenance man, and you can't pull yourself up by your bootstraps on public interest by saying because he falsely behaved as though he was the manager, therefore we are criticizing the management of Colby House. They're not criticizing the management of Colby House, they're criticizing the man who works there, just as they might criticize the loo cleaner or the laundry woman. There's no public interest in this whatsoever, and it was only the Colby House aspect of it that they even attempted in their own arguments to justify as being public interest. And then they link POSC with the charity. POSC was years before. And in fact, the claimant ceased to have any involvement with POSC on the evidence in 2012, and the renovations of the Jazz Cafe were in 2006. The rest, then, in paragraph 52, the Court of Appeal makes a fair point, favourable to the defendants. Again, at paragraph 53, they are showing they have considerations on both sides. And then over the top of page, qualified at the top of page 287, however, the POSC allegations were not about the management of POSC. At 54, just glance down it, we submit they are spot on there, and 55. Paragraph 56 is more difficult. This is a little trickier, where they say it's telling that at no stage did the defendants contact anyone involved in the actual management of Colby House or POSC to discuss the allegations. It would be a natural and obvious step to take if the article was about the management of these charities and the fact they wrote afterwards. Public interest, we suggest, really should be looked at objectively. So the claimant's supposed concession shouldn't influence the court, and neither should the behaviour of the defendants. It would be much more straightforward, notwithstanding the qualification that the court must have regard to all the circumstances on both A and B. We think that really needs to be looked at objectively. It was always a question of law a common law where there was a jury trial for the court. But I think it's a fair criticism or a fair question as to whether the factors that may be relevant in B are necessarily relevant to A. And then, anyway, they conclude, for all the reasons, which my only reservation is 57, that the judge was wrong to hold the first limb made out. But of course, the judge performed no such analysis at all. Then they go on to 1B, and they conclude that the judge's reliance on a concession was an error on both on the facts, but we submit also an error of law by the judge, and therefore the Court of Appeal was quite correct here to say that he made no such concession, because even if he did make such a concession, if it's an objective test, it's neither here nor there. And then on the second limb, at 64, they open with Mr. Justice Warby's words in Economou, which I submit amply demonstrate how highly elastic it is. Again, it's carefully and correctly worded. At 65, they say, in the present case, the question is whether defendants adhered to appropriate and reasonable journalistic standard, carried out such inquiries and checks, it was reasonable to expect of them as journalists to do so. There's no presupposition there. There's no prejudgment as to what they should be doing in that formula. It's a perfectly acceptable formula. At 66, I accept the criticism here, where they say it is a basic requirement of fairness and responsible journalism, and a person who's going to publish a story without being required to show it's true should give the person. That, with respect to the Court of Appeal, could have been worded better. It is a relevant consideration. It has to be looked at on the facts. It is on cases like this, it is an immensely important consideration, but it is not a requirement. The court has to keep an open mind and has to apply it flexibly according to the facts. Doesn't help very much in terms of predictability for journalists, but it does give them the breathing space that Mr. Price says they feel they don't have. The question in each case, as I said earlier, is has there been an adoption by the public publisher of the defamatory material? If so, then it's a good starting point to say, well, shouldn't you get his or her response to it before you decide to publish and before you decide what you're going to publish? And shouldn't you also cross-check with people who might have first-hand knowledge about it? If what you're doing is you're neutrally reporting something of public interest and you're not adopting, well, that's a different matter. You don't have to investigate. And in fact, as Lord Brown said in Al-Faghi, if you are neutrally adopting and you do start to investigate, you might actually prejudice your neutral reportage. The whole point about neutral reporting is you're not being the investigative journalist. But this is investigative journalism.
You were in Al-Faghi, I note.
I was on the wrong side, yes.
You know all about it. You would accept that there can be a statement on a matter of public interest, even if it is of interest only to a relatively small section of the community.
Absolutely. One's looking at the readership. One's looking at the readership. There's no point looking to see whether people in Wales are reading the Bradford Herald or something else.
Thank you.
Then they go to the Economou case. At paragraph 70 again, I would just question the language here. The circumstances in which a journalist or publisher will be able to demonstrate that it was reasonable not to approach the subject of a potentially defamatory article or comment prior to publication will necessarily be rare. Now, in practice, that may be true, and certainly in the case of adopted allegations. but it's probably not helpful to word it in that way, because it needs to be worded flexibly. It may be rare, but it is not necessarily rare. Am I being looked at because it's 15:15? I am. Yeah. Oh, I haven't done 13.4. Either.
In fairness, she's entitled to another 15 minutes.
Yes, yes, you are entitled to go on for longer.
I will be as quick. I'll be very short when I get to 13.4. Thank you. Then they deal at 73 with the failure to contact the claimant, and they talk about the tenacity of the requirement. And these are important cases. Malik and News Post, Mr. Justice Nicklin and Subban and Badal. And there's no question but that the courts have regarded contacting the claimant as important where serious defamatory allegations are made which are going to cause harm to reputation. But it's obvious on their facts why this is an important factor, but it is not a requirement. It is a relevant factor. And then failure to contact others, the court deals with, as we know, at 76 to 80, and that is entirely appropriate. All of those are relevant. They set out some of the passages from the cross-examination. And then at 83, they do go through the Reynolds factors. They're still calling it a checklist, which perhaps we'd prefer they didn't. But they say it's useful to consider. They're not saying they're bound to consider, they're saying it's useful. And when one looks at each of the conclusions, each of them is justified on the facts of the case. And not only did the judge not do this, but when it came to the misuse of private information, he went through the Murray factors in order to decide whether or not to uphold that. So I think that's probably all, unless there are any questions I can say on Section 4. I need to deal with imputation 13.4. I'll try to deal with very swiftly. Overnight, my learned friend produced the references to the evidence. I can just go to what his case had said. It was the defendant's case is where it came from. It's Core Volume 1, page 92, paragraph 135. It said a number of witnesses who purchased drinks stated that they saw the respondent place the cash they had used to make the purchase in a wooden box or drawer under the counter. Witnesses to the claimant doing it. Now, if you have my learned friend's note, the references are, and I won't ask you to look them up, I'll just simply say what our case is on them.
Do we? I'm sorry. Do we have the note?
It's Mr. Price's additional material note.
So it came through last night with the authorities.
Well, I'm not sure it did.
Oh
in the
yes,
file.
I see. It's paragraph
It's in the file.
paragraph 5 and 6 of the document.
So
They gave copies to the usher.
I'm just looking at it on the incoming email.
Ah.
I'm not finding it at this point. I'm sure it's here. I was trying to do it right.
well, I could summarise what we say quite quickly.
Yeah.
Only one of those listed, 5 of them, say they saw the respondent put the cash in the box, and that is Enrico Wojnicka, who says that it's quoted from paragraph 42 of her witness statement. I used a £50 note to pay for a round of drinks. The claimant placed the box on the counter to place the cash in. So in full view of everybody, the rest of them refer to a box in the bar. None of the others say they saw him put the cash that they gave him into a box. So moving on from that, the starting point again is the amended defence. It's at Core Volume 2, 434 to 436. It's paragraph 14.13.
Fourteen
14.13.
14:13. Thank you.
I don't want to read it all. I want to go to where at the top of page 435, it says he was solely responsible for stocking the bar and the purchase and sale of alcoholic drinks, which, so far as I'm aware, was not actually proved. He did not keep proper accounts, nor did he, between 2000 and 2012, install a cash register to record sales of alcoholic drinks in the cafe to customers. Not to have installed and used a cash register could only have been because he did not want POSC to know how much he was profiting personally from his position. So it was critical that there was no cash register. And then we have the reference to Mr. Wegranowski. Sometime in 2008, the claimant admitted to him, his neighbour, that he was making an undisclosed profit of £200 to £300 per week for himself in buying and selling his own alcohol from a wholesale warehouse through Jazz Cafe. He did not want to account for these sales through the use of a cash register. Cash register is cheap and easy. Cash register enables a business to bag its book. There was no cash register. The claimant at 5 has pleaded a positive case there was a cash register. The case is untrue, as he knows. And at the top of page 436, not to use a cash register can only be because those managing the business, in this case the claimant, do not want to ring up all transactions. There's no other reasons. This is what he had admitted to Mr. Wegranowski. The only reason to assert in the reply there was a cash register when that is not true is because he knows, as is fact, that he was acting dishonestly and had something to hide. Now, the judge finds that there was a cash register. The judge, nonetheless, still finds him guilty of siphoning money out of the Jazz Cafe. So that all then has to hang. And I mentioned yesterday that Mr. Serafin, at the beginning of the trial, and then tried again, just wanted to put in 3 photographs to show that there was always a cash register. He wasn't allowed to because he was too late. Mr. Wegranowski's examination in chief, his evidence, we go to, yes, his witness statement, we go to Core Volume 2, starts at 507, and I want to go to 508.
You will have to take us through this very quickly.
Yes. Oh, well can I just yeah. If we go to 507, I can do this very quickly. Sorry, I should hurry up. He says, it's in paragraph 33, He used to brag about how much money, in other words, as it is frequent, he would say, the Jazz Cafe, he said every Friday and Saturday he'd easily make himself 300 to 400, it's become now. He told me he was working with a friend, and each of them would take a few £100s. Renata was also present at some of these conversations. So the money's changed. No reference to, no reference to he wasn't using a cash register. That sort of conveniently disappeared from the account of the witness. He treats it, the pleading treats it as an occasion in 2008, not as something he'd regularly say. The pleading makes no reference to Renata being there. As I say, no reference to the cash. And then the evidence of Mrs. Siparska, Renata Siparska, is at 42, and she remembers him bragging one evening, and she has also aligned herself with 300 to 400 pounds a night. That is all that it hung on. That is a very serious allegation of theft. That will not do to satisfy the burden of proof. For that reason, we say the judge was wrong, the Court of Appeal was right. And that's the end of my submissions.
Thank you very much, Ms. Page. Mr. Price.
Forgive me if I'm labouring this point, but it is important. My learned friend has made detailed submissions in relation to imputation 13.1, the renovation of the Jazz Cafe. She's done this solely within the context of issue 3, namely unfair trial. The only imputation that's under direct challenge in relation to truth is imputation 13.4. If she'd made a direct challenge in relation to imputation 13.1, which on the basis of her submission she could have done, she refers to crucial findings, flaws, critical elements of the defence were missing, then I would have been able to face it head on, as I've done with imputation 13.4. So we've also got to have a fair appeal as well as a fair trial. And what that must mean, especially when one looks at the statement of facts and issues, is that I have 13.1 in the bag for my argument on nominal damages. Perhaps more significantly than that, I have the most serious allegation by far, as was found by the judge he was entitled to find, which is imputation 13.6, which hasn't been the subject of any challenge, even indirectly, through the submissions on unfair trial. Nor has my learned friend addressed my easy route to an answer to this appeal, which is that 13.6 of itself forms a proper basis for an award of nominal damages. So how does one determine this appeal? In my respectful submission, one goes back to where I started, which is the statement of facts and issues on page 56, tab D, for those with the printed volumes. Bottom of the page, 45.1, should the judge's finding on section 4 be restored? The answer is it should be, because he didn't make any error of principle. He quite clearly stated that the test and the paragraph that my Lord Briggs put to Ms. Page as to whether there was any error of principle in that paragraph, and she didn't really answer the question. He reached a non-perverse conclusion that the defence should succeed. Whether he could have given further reasons, not really here nor there. He was faced with a trial where he had a litigant in person on one side and he had a skeleton argument on the other side. I mean, his only source for the law was Mr. Speaker's skeleton argument, who'd ceased acting for the defendants a couple of weeks beforehand. In the circumstances, he did rather well. But in any event, he reached a non-perverse conclusion that the defence should succeed. I'm not going to repeat all the submissions that I have made in Schedule A to the case on the details of what the journalist did and the Court of Appeal's criticism of it. It's in Schedule A. It's also in the chronology and dramatis personae that I submitted after the respondent's case. It's now conceded by my learned friend that this defence has to be applied with a maximum flexibility, and if it's applied with a maximum flexibility, then it's rather difficult, or it's much harder, to overturn the judge's conclusions on grounds of perversity. That must follow from the flexibility of the test. So the answer to that is, should the judge's finding on Section 4 be restored? Yes. Next question. Alternatively, was it open to the judge to find that the respondent's reputation had been shot to pieces, thereby depriving him of any damages other than nominal on the basis of what it had been open to him to find had been proved? It's common ground that if it was open to him to find that imputation 13.4 was proved, then the answer to that is yes. And for the reasons that I've given in Schedule B to the case, that was clearly a finding that was open to him on the material before him at trial. But in any event, don't have to worry about imputation 13.4 because imputation 13.6, and if I have to go to imputation 13.1 as well, and the various findings that were made by the judge. But even if we just leave it at imputation 13.6, a finding that has not come under any scrutiny through the front or back door in this appeal, that is, you can answer that question yes on the basis of that imputation. I've particularised why that is so. In the case, I've referred you to Joseph and Spiller, which came back to a trial after that hearing in the Supreme Court, and there was a finding of forgery, which resulted in a nominal damages award. That's an instance of litigation misconduct, but there's case references there to Grobbelaar, which was a case of partial truth, but not total truth, and partial truth having the effect, if the judge so concludes, of reducing the damages to nominal, if it would be an affront to justice for this claimant to receive anything more than nominal damages in the light of what has been found against him, and in this case found against him that he's conned people into passing over their life savings and then stolen them. And then worse still, he's defrauded them through the bankruptcy process. That's imputation 13.7. So the answer to that is yes. I'm not seriously argued to the contrary by my learned friend. But I think, if at all, either in the case or in oral submissions. So then the next question, was the Court of Appeal correct to find that the trial was unfair? I'll leave that to my learned friend, but there was some debate about what should happen to issues 1 and 2 that I've just gone through if the answer to that was yes. And I would submit that it is at least open to this court, if this court thinks it's an appropriate outcome, to take the findings in relation to...
Couldn't hear that.
Take the findings in relation to 45.2 that haven't been challenged and still come up with an award of nominal damages. That is a route this court can take if it wishes, and that an unfair trial should not necessarily be an all or nothing situation. Both sides have left the question of what would happen if the trial was unfair to await whether a finding that it was unfair, if that's what the court was going to find, and also how the other issues fell to be determined, raised by the appeal. But I
was wondering about the last sentence of paragraph 5 of your case, Mr. Price, if you've got that to hand.
Yes.
It's at 62. The question is whether his conduct of the trial was such as to render it unfair, thereby vitiating all his findings. I took that as a concession, a logical concession, as I thought, that if it was unfair, all his findings were vitiated. Yeah. But you didn't mean it that way.
Well, no, I did mean it that way, but if I was wrong...
You didn't mean it that way?
Well, I mean, obviously, that was my understanding, yes, of course.
Yes, that was your submission yesterday morning. In fact,
Yes, that was my understanding.
if conduct of trial unfair, all judges' findings vitiated.
Yes, but we are in the Supreme Court now, and if if we proceeded on an understanding that, I'm sorry, Milady.
No, I want to hear your sentence.
If both parties have proceeded on a misunderstanding of what the position is following a finding of unfair trial, well then this court should not rely on that as in any way constricting it if it felt that it should have the opportunity, notwithstanding the finding of unfair trial, that only certain of the findings go and that the parties can avoid the horrendous vista of a retrial.
Could I ask you for some help on this? Is it possible that if a defendant, if the claimant, having obtained a ruling that a trial was unfair, and having the benefit of advice, as the claimant now does, could that claimant be given the option to say, no, I don't want a retrial, I simply want this? And has that possibly happened in the fact there's no challenge to the Court of Appeal's order on remittal?
Could he be given the option? I'm sorry.
Yes. Say, it was an unfair trial, but I simply don't want another trial.
Well, he could certainly be given the option, I would have thought, but the court could also, even without giving him the option, come to the conclusion that it could having answered question 2 affirmatively, award nominal damages. That should be an option available to this court. But
more widely about the remedy for unfair trial, because a retrial is not desired by either side.
yes,
Well, one option, it's a matter for parties, but one option would be for the court to reach a decision in principle as to whether the trial was fair or unfair, issue a judgment giving its ruling on that issue,
yes,
but not making any executive order until the parties had an opportunity to consider what order they sought in the light of light of a court's judgment. And I mean, it's always open to parties to compromise proceedings if they decide that that's what they want to do.
Obviously, in this sort of case, inevitably costs, particularly when there's a CFA involved, become an insuperable difficulty to resolution. That's the reality of it. But certainly that's one possible way forward. In my respectful submission, it would be helpful and appropriate, given the agreed issues between the parties, that in that judgment, issue 45.2 is addressed. In other words, the question of whether it was open to the judge to award nominal damages on the basis of the imputations that are not under challenge. And that would help, certainly. Possibly that could lead to settlement. I think it's probably unlikely, but it might also focus the parties' minds. That would be
Mr. Bradley,
yes.
Ms. Page told us, I think, with assistance from Ms. Marzek, that what happened in the Court of Appeal was that they gave a draft of handed down presumably their judgment in draft. There was then time for reflection, and then there were submissions about what order should be made.
Yes.
That they didn't ask for the limited order which the court made. I think I understood Ms. Page to say they asked for a retrial.
Yes.
But the court decided to make an order merely for quantification, an assessment of damages hearing.
Yes.
What seems to me, but I want to hear what you say.
Yes.
On a basis that must reflect back on some findings of truth or falsity. Yes. And that wasn't then cross-appealed before us.
No.
Is that your understanding of where we are in terms of what's actually happened?
I think so. I emerged after the judgment had been handed down, but before the ancillary orders had been determined.
Yes.
And I made submissions to the effect that I made and was drawn to my attention by Lord Wilson, that the effect of a finding of unfair trial was that all the judges' findings were vitiated, and that would include those that were favourable to the claimant, because certainly not my client's fault that if there was an unfair trial. So that would mean I could argue, if I was going to be arguing it, the Section 2 point, which the judge dismissed on the technicality. That's the truth defence, where he He said that Section 2.3 didn't apply, it wasn't a common sting case, so that truth should be open to me at a retrial. I also submitted that imputation 13.4 had not been finally concluded because there were a part of the reason apparently for the court's decision was that the claimant hadn't had a proper opportunity to cross-examine the witnesses. So there was quite detailed submissions. I said that nominal damages were very much on the table even without imputation 13.4 being there. And for example, the forgery imputation should be live at a retrial, Colby House, everything. We go back to the state of the pleadings as they were before the trial before Mr. Justice J. That was what I was submitting. These were quite complicated points. We didn't get any form of judgment back. We just got an order in the terms that the court has in the bundle.
Oh, I'm inclined to think, as presently advised, that a judgment produced by a judge who was biased against one party is a thing written water. If the court is of that view, then it remains open to the parties to reach any agreement they want to, as to, for example, the assessment of damages on an agreed basis. But the court has to apply the law.
Yes.
We're not in the business of organising settlements for parties.
No. There's a case called Bobulus and the Economist, which I think I relied on for this proposition when I was submitting that my client should be able to run a truth defence at a retrial, which they were prevented from doing. And that has the reference to written water in it, the outcome of the first trial. And that wasn't an unfair trial situation, but the general point is that where there's a retrial, the findings of the first trial are written water. So, yes, that was the line that I was taking, and I've only just taken the alternative line because it was raised in the course of...
But if that's not a pragmatic solution, then it's up to the parties to reach a pragmatic solution.
The cost in this... there's £160,000 of base costs in the Court of Appeal, and that's without success fee, and there's probably going to be £250,000 costs on the other side. For this Supreme Court
You can't
case.
get blood out of a stone.
My clients, that's against my clients. So they still have some remaining equity in their home. There's a charge against their home. Carter Ruck are in there first because of the costs from the trial. If they came off the record, they got a charging order. Now there's another charging order. So we're talking £500,000, if not more. In those circumstances, it's very difficult to see how there can possibly be a resolution. And in terms of an assessment of damages, it has to take place by reference to findings. It can't sort of happen in the air. It has to take in the context of the imputations that have been found to be true. That's the submission I've picked up on, the matter having been raised by the court. If the court was to invite the parties to agree that the court should assess damages, it would have to be in some form of context, and then there might be a disagreement about what that context was, because I know as far as my client's side, we would be submitting that those findings of fact that are unchallenged, and if 13.4 survives that as well, that those should be taken into account. So it may be a way forward, but I think it's rather difficult to do that in the abstract. I did agree to divvy up time with Mr. Metzer because, of course, he's very keen to persuade the court that one doesn't even have to factor this issue into account at all, because the answer is that it wasn't an unfair trial. Obviously I want to give the court the maximum amount of assistance.
Well, it rather sounds as though, as matters stand, the parties don't have any agreed position to put to us. So when we adjourn in a quarter of an hour's time, it's open to the parties to write to the court inviting us, if all they want in the first instance is a ruling on the points of law, then we can give a ruling on those points of law, and the parties can then consider what form of order they would like the court to make. But if we don't hear from you, obviously we'll proceed in the usual way and draw up an order.
Yeah, I think the most helpful route would be for the court to make its determination in relation to issues 45.1 and issues 45.2, and of course the fact and the unfair trial, the three issues, that the main issues in the appeal, and then that would give some framework in relation to which the parties can contemplate the way forward. And I repeat the point that issues 45.1 and 45.2 must be judged in the context of what a fair-minded judge could have done.
Well, perhaps Ms. Page can have an opportunity to consider this with her client and let us know in writing if that's an agreed position or not.
Over to Mr. Metzer, unless...
Could I, before you sit down, ask a factual question? Paragraph 77 of your case, Mr. Price.
Yes.
It's at 79 in the bundle.
Yes.
Fourth line.
Yes.
The claimant freely admitted that he'd lied to his investors. Now, can you give me the reference in the transcript where he freely admits he lied to investors?
Yes. That is Mr. Metzer's section, unfair trial.
Very well. Okay.
Well, I don't want to pass the buck, but...
Right.
So
perhaps Mr. Metzer could do that sooner rather than later.
Yes.
Mr. Metzer.
My lady. I don't think I'll be longer than 1 o'clock, but I think we were given 45 minutes on reply, and I've recognised...
No, but you overran quite a lot yesterday.
I accept that, and I apologise for that. I will do my very best to finish within 10, 12 minutes, which I think is time. We'll have the answer, my Lord Wilson's question momentarily for my learned junior. Can I just make a few general observations and then deal perhaps with the concerns which is clear from the court in relation to disposal? First point to make, I think this came at an early stage. There was a reference, I think, to Lord Kitchen's observation in relation to where the tour de force reference is to be found. That's to be found in the judgment at paragraph 89. That's 332. You'll see there that the judge dealt with the claimant generally, and then he compliments him by saying in the middle of the page, I warmed to the claimant more as the trial progressed, and his closing address to me was in many ways a forensic tour de force. I should add, during his cross-examinations of the defendant's witnesses and his closing speech, the claimant purported to give further evidence. As a self-represented litigant, I do not criticise him for this, but it came late in the context of the closing speech. So that's the reference to complimenting the claimant. I'm going to ask the court, I'm going to do it very briefly, paragraph 90 deals with the position about his legal representation, and thank you. Paragraphs 91 and 92, I'm going to ask the court respectfully to see how he deals with the claimant's evidence generally, both positively and negatively, and there's a balancing exercise that the judge carried out in relation to that. Second point that I would wish to take while we're in the judgment, could I ask the court please to note the references, the judge's positive findings in favour of the claimant, Mr. Serafin, in relation to the 8th to the 13th meanings. Those are at paragraphs, and I'll just give the references, 257 and 260, 266 to 267, 273 to 274, 275 to 276, 280 to 281, and 282 to 283, and overall conclusion 295. My learned friend today accepted, in answer to the question from Lady Arden, that her case is essentially one of actual bias, and that is consistent really with the suggestion of animus in the Court of Appeals reference. We respectfully submit that is a high bar and a very serious imputation in relation to a High Court judge. Third point to make relates to the bankruptcy undertaking. That this point is the one that's developed in relation to an allegation. This really was a failure to disclose by the claimant. Can I ask the court briefly to go to the Respondent's bundle at the bottom of page 371 of the pages, that's at EB 2485. If the court could please go to the very bottom of 2485, the judge says, I'm not sure it's clear what the actual restriction is in relation to the bankruptcy undertaking. My lord, it's clear the claimant was informed, because if you see the letter at 185, what are the terms of it? We probably should have pushed for this, I say. I don't think the annex setting out the restriction was disclosed, and then and the judge then questions Mr. Serafin in relation to that and maintains that he hasn't seen it. The relevance of that is, if we then go to the judgment, back to the judgment of paragraph 29 of the judgment, which is at EB 321. This was something that the judge very properly was investigating. It robustly, we say, rejects suggestion the judge was unfair or even wrong to do so. It's not a matter of burden of proof or the defendant going on a fishing expedition. This was a document which plainly failed to be disclosed and which the claimant failed to do so. He simply, you'll see that in the second line of paragraph 29, the terms of his BRU have not been provided.
But you didn't push for it.
I didn't push for it.
You said you didn't push for it.
Yes.
You did at the pre-trial review. You didn't ask for an order for it.
I wasn't at the pre-trial review.
Well, then whoever was didn't ask for an order for it.
Yes, I don't know who attended in that.
No, well, that's irrelevant.
But I accept that, my lord.
Yes, very well.
Yes. But it's certainly an issue as to whether that the judge was never provided with it. I take the point no further than that. The next point in relation to the point that was raised this morning, judgment at page 100, at paragraph 188 at 351. This was the issue about the who renovated the cafe, and I'm just going to ask the court respectfully to look at paragraph 188 in relation to what we say is a proper basis for the judge to draw an adverse inference against the claimant on the evidence provided on the question of who renovated the cafe. More generally, we respectfully submit that the points advanced today and yesterday afternoon by my learned friend, which we respectfully submit were wider than and new. They certainly weren't in the case, the written case, are appeals primarily against case management decisions dressed up as unfair trial. Can we just go briefly to paragraph 6 of the judgment, which is at page EB 316. In which the judge himself said this was a difficult trial to conduct and the resolution of some of the issues had been far from straightforward. The claimant failed to number the bundles before the trial, and my clients had to prepare numbered bundles at very short notice to avoid the trial being vacated. We say that judges do have a very wide discretion when it comes to case management. The issues of under CPR 3219 and issues of disclosure are quintessentially matters of which go very fundamentally to case management. And these days, under active case management, the judge is entitled to intervene in relation to that issue of ensuring trials are properly controlled.
The reference to a Mackenzie friend, is that a reference to a lawyer behind the scenes, or was there somebody in court?
There was somebody physically in court.
There was?
There was, but he was not a lawyer.
Not a lawyer?
That's right. Thank you, my lord. I want to deal with the point that Lady Arden raised this morning. I think I've finished in relation to all other matters, save for the remedies point, except I want to take you very briefly to the authorities, which I think may help in relation to Lady Arden's observation, and one other point. Can I ask you, first of all, to go to the case of Southwark LBC and Kofi Adu? That's at tab 40 of the judgment of the authorities bundle.
Page.
The page, please. It's paragraph 142, and it's at EB 1576, my lord. I'm going to ask the court, because that is significant in our respectful position, a number of points in relation to how far a judge can go. At paragraph 142, there's a reference to the wide degree of latitude in which a judge conducts proceedings, and at paragraphs 145 to 147 are the references there to judges being very much more proactive and interventionist, and there's a reference there to circumstances in which the judge, essentially the first instance judgment, should be permitted to have considerable latitude. So there's that case. Then, dealing primarily with Lady Arden's observation, can I ask you please to go to Re G, which is at tab 35. Paragraph 53. It deals with the question. There's two other references which I hope will be, sorry, page 1441, Lord. It's the question about essentially the judge having no right to have representation on these type of issues. Can I ask you please to look at paragraph 53? First of all, there's a reference to the family justice system and the hard-pressed, hard-working judges in the court, which means that family judges have to manage hearings before them robustly, and this requires intervention at times, and then talks about the judge's task being almost impossible at times. Then this. The second is that I am deeply conscious of the fact that the one person from whom this court has not heard is the judge, who would no doubt have had much that she could valuably have contributed to the evaluation of the process. There's further, can I ask you, just for completeness sake, to look again at paragraph 31. I don't ask you to look at it now, but paragraph 31, the second half of that paragraph, dealing with the fact that judges have different styles, and there are talkative, uncommunicative, robust, even irritated judges, provided the judge's behaviour does not stray outside acceptable limits. That's at page 1436. Sarabjit Singh, there's one reference I would ask to look at. That's tab 37, and the internal paragraph is right at the end. It's 53, 1 to 3. That's EB 1523. It's said that, of course, that case was a tribunal's and not a court of record, but it gives some assistance, perhaps, to the observation of the question Lady Arden asked. An allegation of bias or misconduct can too easily be raised by a disgruntled litigant, and then it deals with the circumstances in which you could properly grant permission. And then this: if an allegation of bias or misconduct is raised, which is a judge sufficient to merit the grant of permission to appeal, it should be normal practice for the upper tribunal thereafter to obtain the written comments of the judge concerned, both in fairness to the judge and provide the upper tribunal with a fuller picture. Such written comments of the judge, where obtained, should be provided to the parties for the purpose of the appeal here in the upper tribunal. And then there's a reference to the being retained on file for the Court of Appeal.
You say it's the tribunals in that case, which is correct, but my understanding was it applied more widely, but the practice was being applied more widely.
Yes, well, I think that is right. I know that you've asked for us to see if we can find further authorities on the point, and we will try and do that. Can I finally...
There wouldn't be a transcript, would there, of what transpired before the first-tier tribunal?
I think what happened there is a reference to that. Yes, I think it's at... There was no transcript. There is an explanation as to what happened. There was just for your reference, I think it's at paragraph 25, deals with how the court, in the Court of Appeal, dealt with the description. That's at 1520.
Very well.
And finally... sorry, my lord.
I was just saying it's a bit of a moving target, because I think the position about transcribing from the tribunals has changed quite recently.
That's right. And finally, on the point that you raised respectfully, Lady Arden raised, can I ask you to go to M&P Enterprises at tab 16, the authorities bundle. That's... and the reference dealing directly at this point is right towards the end of the judgments. It's at EB 1131, at paragraph 229. There's a reference by Mr. Justice Hildyard saying, it was not, however, an easy trial for the judge either, echoing the words of Lady Justice Black in Re G. I have undertaken the requisite detailed review with the benefit of hindsight of a tortuous trial, being deeply conscious of the fact that the one person from whom this court has not heard is the judge, and then he completes the quote in relation. So there is recognition judicially of the difficulties of this type of situation without the judge's input. And my last point in relation to this case, can I just ask please there's a few references to M&P Enterprises that I think help in relation to, if I can put it as neutrally as possible, the sort of behaviour that is not condoned by best practice in terms of a judge, but falls short of being unfair. But I think it is of some assistance to this court, I hope. Can I ask you please to go, first of all, to paragraph 43 of the judgment, which is at EB 1084.
BB what?
1084, my lord.
Thank you.
Thank you. There's no real dispute. A number of background factors and circumstances have resulted in the appellant's case being in a somewhat chaotic state. And this materially impacted upon and complicated the judge's task in conducting the trial. The reference to chaotic state was something I think I dealt with yesterday. This was a trial which was at some stage, many stages, and in the course of the trial in aspects, in some level of chaos in terms of the claimant's case. I mean, no disrespect to him as a litigant in person, but it was a reality. And then if we go, please, to other paragraphs that I think of some help. First of all, paragraph 74, 1091, middle of 74. The hearing cried out for firm management by the judge, failing which it could have spiralled out of control. And I made the points yesterday that the time limit was met. There were other issues that the judge controlled properly in our respectful submission. If you then go, please, to 102. That's at 1098 on the electronic bundle. No, nor, in my view, would a reasonable observer have thought criticism to connote or give appearance of bias as contrasted with crotchety or grumpy behaviour such as sometimes associated with judges, however regrettably without suggestion of bias. And then at 178, um, 178 is at EB 1117. And this is perhaps very helpfully put. Whilst Sphinx-like inscrutability, most especially during the process of eliciting and testing the evidence, may be the wisest attitude and the safest objective, it is hardly unknown for judges to betray their views and even scepticism. And then there's continuation in relation to that. I think there are three more references, nearly finished. 210, which is at EB 1126. That was dealing with how the judge was to counsel. In the middle of the page, appellate comments made by the judge to be at the least abrupt and regrettable on the basis of the transcript alone. And then, middle of the page, the state of conduct of the appellant's case occasioned delay was oppressive, in my view, inappropriate and intimidating. Such conduct made worse an already difficult position for counsel, for no judicial benefit in the end. The judge was plainly a difficult tribunal before which to advance an ill-prepared and disorganised case. And then there's a sympathy for the counsel. And finally, really, 212 through to 214. And recalling that the judge did not find this trial to be unfair, I have not found either judgment straightforward. In my assessment, the judge was excessively interventionist, disparaging, did unsettle counsel, and then drop a couple of lines, allowed herself to become more involved in correcting counsel, lecturing about courtcraft than in the sober and detached adjudication of the case, disparaging counsel, unnecessary and discourteous. And then in the next paragraph, in almost every case, the judge's interventions were in strict terms justified, but importantly at 214 at the bottom, the middle of 214, I have concluded, though difficult and unsympathetic, even sometimes disparaging, the judge's interventions and criticism of counsel were not the real reason preventing the appellant's cross-examination, developing momentum and cogency. And then, in my judgment, the true source of difficulty is the state of the appellant's case, not the trial process. That's, I think, all I wanted to say in relation to judicial conduct falling short of unfairness.
Well, Mr. Metzer, it's now well past 1 o'clock.
Sorry, my lord.
Yes.
You need to answer the question.
Yeah. I think the question that I need to answer is at page 683. I think the question was asked, where would we find the reference to Mr. Justice?
Freely admitting that he'd lied to
Yes.
investors.
EB 683, and it's an E to F.
Thank you.
Thank you.
But
The respondent's bond.
Yes, please.
Yes?
The respondent's bond, it's at 147D to H.
Thank you.
Thank you.
my lord, in one sentence, we recognise the difficulties this court has, but as everyone seems to recognise, a retrial and everything that flows from that would be, frankly, disastrous from everyone's point
Well, then there's got to be some compromise at last.
Well, of course, one would hope that, but
Yeah.
there is some pessimism. Thank you very much indeed.
Thank you. Well, thank you all very much. We appreciate the gravity of this matter for those involved, and we'll do our best to provide you with a judgment as soon as we can. The court will adjourn.